Hi everyone, I am Anshula Gupta from Laudable. Today we will be studying brief introduction to Civil Procedure Code 1908. Do listen this video till the end and don't forget to like this video, share it with your friends and subscribe the channel for more such videos. So, Civil Procedure Code 1908. As the name makes it very clear that it is a procedural law. So, firstly we will understand what is procedural law. So, there are two types of laws, substantive law and procedural law. Substantive law tells us the rights or the liabilities which are made available to the person through many acts like Indian Penal Code 1860. It describes various offences punishable under criminal acts. So, substantive law means those facts which create rights or liabilities on any person. And second one is procedural law, or it can be called as adjective law. It prescribes a procedure or the machinery for the enforcement of the rights or obligations which are provided to a person through substantive laws. For example, Code of Civil Procedure 1908, Code of Criminal Procedure 1973. Now, firstly we will study the history of the Civil Procedure Code 1908. So, till 1859 there was no uniform codified law for the procedure to be followed in civil courts, as in those days there were two types of courts, crown courts and provincial courts. Crown courts were there in presidency towns and provincial courts were there in mofusils. So, firstly, what are presidency towns? Presidency towns example are Madras, Bombay, Calcutta. So, in these places there were crown courts and provincial courts were there in mofusils. And what are mofusils? Mofusils were those areas which were situated outside the presidency towns. Now, in 1859, a uniform civil procedure code was introduced by passing of the Civil Procedure Code 1859, but this code was not made applicable to Supreme Courts and Sadar Diwani Adalats. But in 1861, Indian High Courts Act 1861 was passed and it abolished Supreme Court and Sadar Diwani Adalats, and it also established high courts at Bombay, Madras and Calcutta and made the Code of Civil Procedure 1859 applicable to these high courts. Then till 1908 code was replaced 4 times, one in 1877, then in 1878, then in 1882 and finally 1908 Civil Procedure Code, which we are following till today, was passed and it overshadowed the defects of earlier codes. Now, we will understand the worldly meaning of Civil Procedure Code. So, firstly, what is civil procedure? Civil procedure means a body of law. That means a proper structure has been given to some law which is concerned mostly about the methods and the procedure which are used in civil litigation. You well even know that there are civil litigation and criminal litigation mainly, and the code means a systematic collection of statutes. Like in the code, sections have been given in a proper system, like step by step things have been made clear and procedures have been elaborated. So, code means a systematic collection of statutes, body of laws so arranged as to avoid inconsistency and overlapping. So, Civil Procedure Code is that branch of procedural law that deals with civil matters in deciding the cases. Now, what is the object of the code? Object of the code is generally given in the starting of the code or every act. So, object of Civil Procedure Code is to consolidate and amend the laws relating to the procedures and practices followed in the civil courts in India. It is very important, so I repeat it, to consolidate and amend the laws. To bring together all the laws is consolidate and amend all other laws which deal with civil cases. So it consolidates and amends the laws relating to the procedure and practices followed in the civil courts in India. Now, the most important point is next point. It is asked in many examinations that Civil Procedure Code was passed in 1908. And when this act came into force? It came into force on 1st January 1909. This is told to us by which section? Section 1 tells us that Civil Procedure Code came into force on 1st January 1909. Now, what is the extent and application of the code? So, this code extends to whole of India except the state of Nagaland and the tribal areas. This is also very important for prelim examination. So, this code extends to whole of India except the state of Nagaland and the tribal areas. It is also given in the code that the concerned state governments may make provisions for the application of this code to whole or part of the state of Nagaland or such tribal areas by notification in the official gazette. Now, I would like to bring to your notice one most important thing, that since 31st October 2019, this act applies to Union Territory of Jammu and Kashmir and Ladakh by Act 34 of 2019. So, it is very clear that prior to 31st October 2019, if you remember, that Civil Procedure Code did not apply to the state of Jammu and Kashmir, which has now been made a Union Territory of Jammu and Kashmir in one part, and other part is Union Territory of Ladakh by Act 34 of 2019. Now, what is the scheme of the code? The code has two parts. The first part contains 158 sections and the second part contains 51 orders and rules under them. And each order contains rules that vary in numbers from order to order. And also there are 8 appendices which give model formats such as pleadings, decrees, etc. Now, what does the body of the code tells us? Body of the code lays down general principles relating to power of court, and the second part, that is the schedule, provides for the procedure, methods and manners in which the jurisdiction of the court may be exercised. The first part only tells us about the power of the court, and the second part, that is schedule, tells us about the procedures and methods that can be applied by the court. Now, in case of conflict between sections and rules, court shall prevail and rules can be changed. It means rules are subordinate to code. Also, one most important thing, the provision of the code can be amended only by the legislature. So, not judiciary and not executive can make any change in the code. And it is a general law and it will not affect the local or the special laws which are in force already. So, in case of conflict with local or special laws, the local or special law will prevail over the Civil Procedure Code. I hope you understood all the points which are explained in this video, and for PDF of this video you can find the link in the description below, and you can also post your queries and suggestions in the comments, and don't forget to like, share and subscribe this video. Please stay at home and stay safe. Thank you.